We're glad you're here. I'm Chris Fitzsimon with NC Policy Watch. Welcome to this crucial conversation about what the Supreme Court nomination, what's at stake, what it means for us. There's not much going on in North Carolina in the courts. So it's a good day to do this. I want to call your attention to a couple things. One is on your table is this publication called Altered State, which NC Policy Watch published this past fall about what we think is the damage done to North Carolina in the last 5 years of a conservative rule. Turns out they weren't finished. Things are continuing, but we hope this sort of gives you a perspective about what's happening in North Carolina. Most of it was written by Policy Watch reporters, which leads me to my next point, which is we are hiring some new reporters. So if you know anybody who's interested, please look at the Policy Watch website. We're very committed to doing journalism and as a way to keep the public informed as the mass media continues to shrink. But today we're thrilled to have Professor Gerhardt here to explain to us what's really at stake with the Merrick Garland nomination and other things happening in the federal judiciary. And here to introduce that and him is Rob Schofield.
Thanks, Chris. I'm Rob Schofield, NC Policy Watch also. Thank you all for joining us. Thanks to our online audience who'll be watching us on Periscope and on the internet. It's really been amazing that it's been almost 2 months now since President Obama nominated Merrick Garland, the Chief Judge of the U.S. Court of Appeals for the D.C. Circuit, to fill a vacancy on the Supreme Court. To date, however, Senate Republicans, including Richard Burr and Thom Tillis, have remained adamant that Garland's nomination will not even receive a hearing, much less an up or down confirmation vote. Yesterday, in fact, you all may not have seen this, Senator Tillis told a gathering at Campbell University, there was a gathering of Campbell University faculty over at the law school here in downtown Raleigh. He said it was pointless to even attempt to proceed with confirmation process for the Supreme Court nominee once the presidential primary season is underway. For those of you who may have forgotten, the Iowa caucuses actually took place on February 1. Councilman Scalia died on February 13. But of course, the primary process was underway well before February 1, so it really begs the question of how far back we do go. Our guest speaker today, to him, this is an important and disturbing turn in the history of the court and the politics surrounding it. As he has explained in a variety of national publications, Merrick Garland is one of the most distinguished and well-prepared nominees for the Supreme Court in its history. And if senators follow through with their plans to ignore the nomination, it will have important implications for the future of the Supreme Court. And our speaker, of course, is Professor Michael Gerhardt. Gerhardt is the Samuel Ashe Distinguished Professor of Constitutional Law at the University of North Carolina School of Law. He specializes in constitutional conflicts and has been active as a special counsel, scholar, advisor, expert witness, and public commentator on all of the major conflicts between presidents and Congress over the past quarter century. He's written several books. His extensive public service has included advising congressional leaders and White House officials on numerous constitutional issues, including judicial nominations, recess appointments, impeachment, health care reform, the filibuster, and the debt ceiling crises. In 1992-93, he served as one of the 8 members of the Justice Department transition team for President Clinton and wrote the judicial selection policy for the incoming administration. He's also the only legal scholar to participate in Supreme Court confirmation hearings for 5 of the 8 justices currently sitting on the Supreme Court. He served as special counsel assisting the Clinton White House on Justice Stephen Breyer's confirmation hearings. In 2005, he advised several senators on President Bush's nomination of John Roberts as Chief Justice, and he testified as an expert witness in the confirmation hearings of both Justice Samuel Alito, the confirmation hearings for Justice Samuel Alito. In 2009-10, Professor Gerhardt served as special counsel to Chairman Patrick Leahy and the Senate Judiciary Committee. He is, in other words, one of the nation's experts on this subject, and it's a great honor for us to have him here. Please join me in welcoming Michael Gerhardt.
Well, thank you so much, Rob. Thank you for the enormous honor of being able to visit with you all today and to talk about a subject of mutual interest. I have to begin with the disclaimer. I am not going to talk about HB 2.
Not until the questions section.
Except for one thing. It's too compelling to ignore. So I am here in Raleigh, of course, here at the NC Policy Watch, and actually here to talk to a group I suspect needs no introduction to controversies, particularly constitutional controversies in the state of North Carolina. I will have to tell you that Amendment 1, HB 2, and the Senate obstruction of President Obama's nomination to the Supreme Court all have one thing in common. They will all fail. Yay! And they'll all fail for similar reasons. To begin with, they're on the wrong side of history. Beyond that, the American people don't support them. And even beyond that, they're all grounded in very base, coarse impulses rather than the things that define the best in us. The support that you'll hear and know about when it comes to the Senate's obstruction of Merrick Garland's nomination to the Supreme Court is largely driven by partisanship and lacks support in history, the Constitution's text, logic, and that's not a good start. I hope it will be of some interest to you to talk a little bit about the sort of basic process for Supreme Court nominations and some of the basic issues relating to that process. And then, of course, we can talk further about it if you have questions or comments. But to begin with, we all know the tiny little bit the United States Constitution has to say about this. The Constitution says that the President has the power, has the authority to appoint, with the advice and consent of the Senate, justices to the United States Supreme Court. And so President Obama obviously has done his part. He's nominated somebody to fill the vacancy left by Justice Scalia. And I should say, just somewhat parenthetically, but because I'm a law professor, the parenthetically is a little long. I come to this with slightly mixed feelings. Justice Scalia was actually my constitutional law professor. And I have known him, or had known him, for over 3 decades. And actually, I had helped schedule one of his last public appearances, which happened at the Union League in Philadelphia, in which we had the opportunity to talk briefly. And he was always, to his credit, very cordial to me, very tolerant, knowing that I didn't always agree with him. In fact, the very last thing he said to me was, Professor Gerhardt, so how am I doing? He would always say that with a twinkle in his eye and a smile on his face. And I said, Justice Scalia, we just don't have enough time to talk about that. And he, of course, laughed. And and so I don't talk about any of this with any great deal of sort of personal relish. The circumstances that often give rise to vacancies are, in a very real sense, tragic ones, unfortunate ones, but inevitable ones, oftentimes. And it so happens that when we talk about Justice Scalia's vacancy, it's important, I think, to define at the outset, even before we talk about the actual process, the context in which it arose. So Justice Scalia died, as Rob reminded us, February 13th. And what is, I think, particularly significant about that is sort of more than one thing. Nobody saw this coming. And I think you cannot forget that fact. I happened to be at a conference in Atlanta on the Thursday and Friday preceding, and one of the last panels at that conference involved 3 of the nation's leading journalists covering the United States Supreme Court, including Dahlia Lithwick from Slate, Bob Barnes from the Washington Post, and Adam Liptak from the New York Times. And as Adam will tell you, and I was there to see this and know it's true, on this last panel, somebody said, well, will the Supreme Court be an issue in this upcoming election? And Adam, fast out of the box, said, there's no way it's going to be an issue. Nobody is sick or dying. They don't expect a vacancy. When people have said for decades and a lot of years it's going to be an issue in the campaigns and turn out never quite to be. He said this on Friday. Then on Saturday, he was headed from Atlanta to St. Louis, where he was conducting a really special class at Washington University in St. Louis on the Supreme Court. And so he was in class all day on Saturday and then turned his phone on. So if you want to know why the New York Times story on Justice Scalia doesn't show up until 4 a.m. on Sunday morning, it's because Adam didn't turn his phone on until about 6 p.m. And then he turned his phone on and, excuse my French, all hell breaks loose. And he realized, he's got messages, his phone's about to burst and everything else. And the entire world of constitutional law changed. And what you are largely witnessing, sort of to tell you one of the takeaways on this, is what happens when your national leaders decide to improvise. And much of what you've been watching over the last several months is a number of senators and others improvising in response to this vacancy. They didn't see it coming. They didn't have exactly a game plan or strategy in place to deal with this, and the same is true of the other side. And so a lot of what we're seeing is literally being made up on the spot. If it seems kind of not well thought through, and it seems like people haven't really sort of considered this very deeply or thoroughly, it's because they haven't. And so really from the very beginning, we've seen sort of the parties, in a sense, divide on this pretty quickly. And one of the critical reasons for that is because of the part of the Constitution I just told you. The president nominates Supreme Court justices, but with the advice and consent of the Senate. And the Senate, with 55 seats controlled by Republicans, is more than aware that this is going to be a transformative appointment to the United States Supreme Court. That's no secret. Everybody understands that whoever replaces Justice Scalia is going to make a tremendous difference in the future of constitutional law. And just to put it in some perspective, I mentioned Justice Scalia being one of my constitutional law professors, and up until the day he died, it literally shaped the role of constitutional law that I taught and lived in, that we all sort of taught, I suppose, and lived in. And that court, of which he was a member, had been shaped by Republican presidents and had not been dominated by or had a majority of Democratic appointees for over 4 decades. We have not lived in a time when there was a majority of Democratic appointees to the Supreme Court until when I was in law school and before. It dates me to some extent. But it's worth thinking about what that means. That, again, really underscores the fact that this is not just your sort of everyday appointment to the Supreme Court, as if there were any such thing now or forever in the future. This is really sort of the beginning of a holy war. This is the beginning of thermonuclear war. This is an appointment that each side understands. Almost everything they stand for and care about is at stake. So if they fight over it, it shouldn't be the least bit surprising. A process that puts the president and senators in control is necessarily a political process. So we shouldn't be surprised that partisanship and politics are part of it as well. That's the context. At the same time, we need to think about a second thing, which is, okay, what else can do we know about this, and is there anything, of course, history could tell us? This is where some of the dialogue takes place. There's a lot of talk about what history has to teach us, if anything, about this, and I can only mention a couple things here. First is, I think, while there's some predisposition to invest history with some kind of sacred quality, we shouldn't. History doesn't bind us. History doesn't tell us what we should do. History might be able to tell us a little bit of what we could have done or could do, but it doesn't tell us what we should do. And as we look to the past, we should keep that in mind. And you can see some of the improvisation on the part of Republican leaders in that the rationale for their opposition has changed. Initially, it was grounded in the idea that we don't do this in presidential elections. The biggest problem with that is that's completely counter-historical. There's no history at all to support that. And I don't say that as just a partisan. I've worked in this process for many decades. Did have an opportunity to sort of write a book on the subject, and more than just that, have a chance to consult with senators on all this. And there's no support for the idea that during presidential election years, the Senate shuts down for business. That just doesn't happen. And it is true that in the modern era, the Senate has slowed down when it comes to lower court nominations. But for those of us who care about distinctions, slowing down for lower court nominations is not the same thing as slowing down for Supreme Court nominations. And in fact, over 20 presidents have made successful Supreme Court appointments to the Supreme Court during presidential election years, or even as lame ducks. Now that's almost half. I'm not good at math, but it's almost half, which is a fact. So as we go through this, if there's nothing else we can do, we can try and keep everybody honest by making sure that they get their history correct. When we do look at history, we can see a couple things beyond what I've already said. Over the last 100 years, to the extent it is relevant, the Senate has actually taken action on every single Supreme Court nomination with the exception of 2. And the only 2 times it didn't were the 2 nominations that were withdrawn. President Reagan's nomination of Douglas Ginsburg, withdrawn within 9 days of that nomination, and President George W. Bush's withdrawal of Harriet Meyer's nomination, which also was trying to break that record of 9 days. And otherwise, every other Supreme Court nomination has actually had Senate consideration. A second thing, we even have Senate consideration of Supreme Court nominations during the Civil War, during World War I, during World War II, during the Great Depression. So the fact that there are important political and other events has not stopped the Senate from at least holding hearings and giving consideration to the particular merits of a particular nomination. That's the history. Now, when we move beyond that, we can ask the question, okay, does the Senate have the power to do nothing? This is a very interesting question in the abstract. As a practical matter, it doesn't take much for the Senate to actually comply with its oath. And so there are times when the Senate does act, does give consideration, and in fact may reject a nomination, or does act, does give consideration, and in fact after floor debate or whatever else, may not take a vote. That's happened a couple times. More often, it's actually acted positively. As Jeffrey Stoney, University of Chicago Law School has pointed out, when you consider the record on how the nomination of a well-qualified moderate nominee has fared in modern times, they are confirmed 100% of the time. That's the record. And so it's fair to say that to some extent the Republican leadership is swimming upstream on this one when it comes to at least historical trends or historical patterns. Other question about history that comes up inevitably is what's the closest analogy? Now this is always this is a tough thing to answer. It's the kind of thing a law professor would ask: is what's the closest analogy? And the secret that I can tell you as a law professor, maybe April will agree, is there's no right answer. But some answers are more correct than others. Now you can spend a lot of time thinking about it. And so my estimation is that the closest analogy, the only thing that really sort of seems to come, I think, anything remotely close, arose when Andrew Johnson was president. Now, many of us probably don't remember that because we weren't here. If you were here, then you should be the one speaking. And so what happened when Andrew Johnson was president? Well, of course, Andrew Johnson was Abraham Lincoln's second vice president, a man that Lincoln said after his inauguration, keep that man away from me. And so Johnson becomes president because of the unfortunate and tragic assassination of President Lincoln. When Johnson becomes president, essentially nobody wants him to be president. And then he proceeded to alienate everybody. And so the Republican leadership in the Senate and Congress at that time responded by passing a law. And in fact, the seats on the Supreme Court are created by Congress through legislation. So Congress passed a law which prospectively abolished the next two seats on the Supreme Court if their occupants died. During that time period. So they didn't want Johnson to make the appointment. And in fact, there were two people that did, in fact, die, and their seats were then abolished. Johnson then is impeached and barely escapes conviction. He leaves the White House. Ulysses Grant comes in, and Congress recreates the two seats, and Grant fills them. That's the closest thing to analogy. Now, if you want to make an analogy between Andrew Johnson and Barack Obama, I would say good luck. If you want to think about the two people that had the highest number of votes public for President of the United States, the top two are Barack Obama and Barack Obama. Johnson got 0. And then you can just sort of go on. And so we can look at some of the rationale, and I want to sort of get to what I think is, I guess what I call the most credible rationale. So one rationale we've already heard, which is, okay, we should let the next president of the United States make the decision. That's why we're doing this. I think, of course, I have a lot of problems with that, but one problem I have with that is I actually don't think the people who say it believe it. Because I think a lot of people who say that they don't want the next president to make a nomination would actually be perfectly happy voting against the nominee even once the next president got elected. For example, Pat Toomey from Pennsylvania has said more than once, we should let the American people make that choice. Choose the president who's going to make the next appointment. Well, when Pat Toomey came into the Senate, he then proceeded, less than 2 years after Barack Obama's first election to the presidency, to oppose Lenny Kagan's nomination to the Supreme Court. Had nothing to do with the American people's preferences. So much for letting the president, in a sense, make that choice. And I don't think Senator Toomey believes that. In fact, he's going on to say, no, there's a second rationale. The second rationale, and this cuts closer to home, is that the Senate needs to take extra special care because this is Justice Scalia's seat, and the court split 4-4, roughly down the middle. Again, my math is always a little shaky, and so because it's that seat, we need to, in a sense, turn to the American people again to kind of have them validate or validate the principle, whatever principle it may be. For example, if the American people were to elect, I'm going to just take a hypothetical, Ted Cruz, then presumably that nomination might look a little bit like what Justice Scalia did, and maybe Senator Toomey would say, okay, that person looks like, I see some public support for that, and therefore I can go with it. There are a lot of this is just a variation really of the first argument. I'm not terribly moved by this argument either, again, because the linchpin of it is really the ideology or philosophy of the nominee. It's not about what the American people say or don't say. Because the American people could speak to this. They could elect, let's say Hillary Clinton president of the United States. But my guess is if Senator Toomey is still in the Senate, he's not going to pay attention to that. He'll pay attention to the fact that he just got reelected to the Senate and say, it's really the people, Pennsylvania people. That's who I'm going to listen to. So you'll notice the ball keeps moving. It's not fixed, which, by the way, if this were a matter of constitutional law, should make us pause. And that's because this isn't grounded in constitutional law. It's grounded in partisanship and politics. Now, when we strip everything away, I think we can see a couple things. I want to first point to what I think is part of what is going on, and then I'll point to what I think is the more credible explanation for what's going on. And I say this without as much trepidation as I used to say. I should tell you, as preface, that I grew up in Alabama. And I grew up in the 1960s in Alabama. And I grew up as a Jew in the 1960s in Alabama. There were 4 of us. None of whom are living in Alabama. And all I can say is, I think I know racism when I see it. And I think some of the opposition is driven by the basest, coarsest feelings that may exist. It has to do with the very simple fact that a black man occupies the White House. When Mitch McConnell says, no, this president won't make it, that's not a stand on principle. That's a stand on racism. And I've seen stands on racism. George Wallace was the governor when I grew up. And I ran as far away as I could, all the way to North Carolina. No. And now look at it. So I don't think we can ignore that. And one reason I point that out, I hate to tell you, is because with the flip of a page, racism is not going to go away. And I also hate to tell you, with the flip of a page, it doesn't mean that a woman who gets elected president is going to be any better off. I don't know that I need to tell you that. But I think sometimes it needs to be expressed openly. Because I do think there is such antipathy and hostility to the progress of women in society. It seems to know no bounds. But I believe, to some extent, it is generational. And I believe this generation that is coming up in a very different way. Not to say it's perfect by any means, but I think that there are hurdles to be gotten over, hurdles yet to be dealt with, that we can expect will arise. And so the road, nobody knows this better than Hillary Clinton, the road ahead is not going to be easy. So where is the principle of all this? Well, the principle, in a sense, is intertwined with some of this. And it is, of course, the basic principle that, yes, we who oppose President Obama making any nomination believe that the next Supreme Court justice should look and have exactly the same outlook that Justice Scalia had. The principle is a principle that of commitment to, lack of a better way of putting it, to sort of strict adherence to original meaning, strict adherence to sort of textualism, strict adherence to so those things that presumably the court had been adhered to while Justice Scalia was the pivotal vote. So I have a couple thoughts about that. I'll concede for a moment that that's a principle. But I also think that that principle tends to conflate results with ideology. It tends to sort of only treat as correct those outcomes we like. Now, I can give you an example from Justice Scalia. Now, Justice Scalia knew that that he and I would not always see eye to eye, and I don't think there was anybody more than Justice Scalia who really hated the idea of the Supreme Court confirmation process becoming politicized. But Justice Scalia, who adhered so strongly to original meaning, only twice in his almost 30 years on the Supreme Court voted to strike down laws for violating equal protection. Only twice. The first had to do with laws that were what we describe as affirmative action measures. Now, you may say that maybe that could be squared with original meaning in some sense. maybe, as he would say, because there was a general sort of hostility and opposition to what we call race-based laws, race-based classification. Maybe. But it's the second case that kind of proves the point. The second time he voted to strike down a law for violating equal protection was Bush versus Gore. And George W. Bush, I'm pretty sure, doesn't fit into that first category. The law that was struck down in Florida had nothing to do with race. It was what we typically would call a neutral classification, which typically would get the lowest levels of scrutiny or the greatest degree of deference. And so even the most strict adherent to the original meaning wasn't necessarily as adherent as one might imagine or want. And so, but to come back to it, the biggest problem with, I think, the principle that may be driving or animating all this is I'm not entirely sure how many people who actually are opposing this really are committed to that principle. To put it another way, they aren't saying so. You don't find Republican leaders until somewhat more recently and somewhat haphazardly saying, oh, there's also a principle involved here. Well, it wasn't the initial stance. The initial stance of Mitch McConnell was, within days of Justice Scalia's death, Mitch McConnell said, oh, this president is going to fill it. It's going to be left to the American people. Nothing about transformative appointments, nothing about this court being split, nothing about principle at all. And then when some members of the Republican caucus said, well, what if in the fall we get shellacked and we need to think about whether or not the Garland nomination somehow is going to be more acceptable to us than, let's say, a different kind of nomination. What about that? And McConnell said, no, I said this president isn't going to make it. Again, nothing about principle in any of that. And so if you want to make it about principle, my suggestion would be make it about principle. Mm-hmm. Make it openly and expressly about a principle of jurisprudence. But the fact is that the Supreme Court confirmation process is a very tough place. It's a very tough place to make very neat and careful distinctions among people's outlooks based on how you think they would vote. The people that have run into trouble in the process have not really run into trouble because they had, I think because of ultimately problematic ideologies. I think it's because they ran into trouble for a couple reasons. Ethics was one reason. Yeah. I think competency was another. And then another, I think, is that they simply were, to some extent, way outside the mainstream in terms of what was acceptable or public approved sort of jurisprudence. John Parker, as you may know, nominee from North Carolina, rejected. He was on the Fourth Circuit, rejected for the Supreme Court. Parker's rejected because he had views on not just segregation but labor that were thought to be, at least by the Senate at that time, unacceptable. And Judge Burr, who was an eminently qualified nominee, is the other kind of poster child that's oftentimes brought up. But I'm actually of a view that Judge Bork's biggest problem was Judge Burr. And I've said this both when I've worked in the Senate and other places, because when I worked in the Senate, lots of people would come up to me and say, well, why can't we make these hearings like the Bork hearings and everything else? And after I finished laughing, I would say, well, there are a couple reasons. The first is that the objective on the Senate side, if you're in the majority and you want somebody confirmed, is not to make it into a popular TV show.
Right.
You want it to be the least watched, most boring production you could possibly imagine. Now, you may not quote me on this, but I will say during the course of one of the hearings on which I worked, somebody, one of the staffs came to me, and it was in the heat of the moment. He said, "Oh, good, Michael Jackson just died." Why would they say that? Because it took the cameras away.
Yeah.
And that made it even less volatile. made it less prone to any kind of public interest. The more, lawyers will tell you, if you have, and you're lucky if you've never heard this before, lawyers will tell you if you have to testify or anything else, what you should be doing is you should give the shortest, succinct statement you can in response to a question. I should say, the shortest, honest, succinct statement in response. That is not what Burr did. And what we would say to any nominee today, Republican or Democrat, it doesn't matter what party, is shut up. And so I often think of a friend of mine from law school, and I tell this to my legislative process classes. It's one of my favorite moments in legislative process because it really illustrates this point. My best friend from law school clerked for somebody named Ruth Bader Ginsburg. And when she was nominated to the Supreme Court, she had asked my friend essentially to be her counsel. And if you go back and you can see this on TV, and there's a point in which then Chairman Biden asked her a question. As you can imagine, Chairman Biden's question goes on for quite a while. Yeah. And he goes on and on for some time. And then he stops and he says to her, do you have a response? Anything you want to say? And then she looks at him and then she leans back, talks to they whisper back and forth. Then she leans forward and goes, no, Senator. That is why she's sitting on the Supreme Court. You know when to talk and you know when not to talk. That is not the moment to start going off on a tangent or anything else. That is exactly the moment to say, no, Senator, I got nothing to say. And that's exactly what I think, that is one of the lessons from the board hearings. The lesson isn't, oh, let's make them as dramatic as possible. The lesson is, let's make them as boring and non-substantive as possible. If that's the case, then it's really hard to imagine you can turn a Supreme Court confirmation hearing into some kind of seminar on how to interpret the Constitution. It's not going to work. And plus, people's votes are probably largely going to track their political partisanship anyway. So when all is said and done, it's a very hard thing to point to say, oh, that's going to vindicate this outlook or that outlook. The fact is we've had somewhat conservative people confirmed over the years, somewhat liberal people confirmed over the years. And if you want to talk about the two most vicious hearings in the history of the United States Supreme Court, I think in some ways Bork finishes third. The two most vicious Supreme Court hearings in American history involved first Louis Brandeis, hearings that lasted over 6 months and were infused with anti-Semitism, and the hearings for Thurgood Marshall. And I would say those two probably are the two most distinguished lawyers and judicial nominees in the 20th century. And those hearings could not have been uglier. And at one point, President Wilson goes to Louis Brandeis and says, look, you're getting beat up in the Senate. I think, do you want to come forward? He goes, no. Exactly the same as Justice Ginsburg's response. Which is, Brandeis understood that there's nothing to be gained really, or you've got to be really careful about this, but not much to be gained by going into the lion's den like that and then just allowing yourself to become a punching bag. So I'm not convinced the hearings are going to become an elevated seminar in constitutional law anytime soon, unless, as I often say, the nominee really likes his current job. If that happens, if you really, really love being on the DC circuit, go ahead, do it. But you don't go in there and open up and talk more than the senators unless you are prepared to be rejected. Because the more you say, the more you get in trouble. So I've already gone too long, but that at least gives you a little bit of hopefully some background on some of this. But I'm very happy to kind of take some questions or comments and go from there.
Well, I get to ask the first one, which is, you've said you think it will ultimately fail, the blockade. What is your prediction? How do you see this playing out in the months ahead?
I would say you get what you pay for, but with me it's always less. And so,
we're still interested.
I think, my personal thought is that if the election this fall doesn't break the opposition, then the Senate's going to likely turn over control. And at that point, it kind of falls apart, and you're going to get a nominee whether you like it or not. The opposition isn't grounded, it's not just directed, I think, against President Obama and just against Merrick Garland. It's directed against the possibility of a Democratic appointee to the United States Supreme Court. I believe that mission will fail.
I have other questions, but let's go to Ray in the back first.
My name is Ray Bowling. I live here in Wallace. Considering that there may be 8 Supreme Court justices on the national scene for a long period of time, how does that affect the work of the court, and how does the snowball effect of the appellate court situation and their decisions affect having just 8?
Right. Yeah, so how does the, if this obstruction persists, what's the effect both on the Supreme Court and the lower courts? Well, if this persists, and it began, let's say, when Justice Scalia died, then the earliest possibility, if we do leave it to the next president, for the seat to be filled would probably be at least a year from the time of Justice Scalia's death. That would be the longest unfilled seat, longest vacant seat in the history of the United States Supreme Court. Let's put that in perspective. That's what that would be. So that's a problem. It means, among other things, we've got a court split roughly 8-8 on really contentious issues. And if the court split 8-8, it's as if the court weren't there at all.
4-4. Math is really not good.
I'm sorry, 4-4. I was thinking 8, but too fast. So if the court split 4-4 with no apparent majority, that means the court effectively wasn't there. The case then is just resolved according to whatever the Court of Appeals below said, and it has to be relitigated. Now, the slowdown that's occurred isn't just with respect to the United States Supreme Court, it is also with respect to lower court nominations. At this point, President Obama has the fewest number of lower court nominations confirmed for a president in his last year in office. That's lower than George Bush, either of the George Bushes, certainly lower than President Reagan, lower than President Clinton. So that's the scenario that we're in. And I think it's partly because I think there are few issues more important to the Republican leadership than court.
I've got a follow-up question to that, which is that for a long time, conservatives have made a huge deal, the grassroots conservatives have made a huge deal of who gets appointed to the court, who gets confirmed. And I think it's only been in recent years, perhaps, that progressives have started to push back. There's a movement of which, a national movement of which NC Policy Watch is a part of, called whycourtsmatter.org. You can check it out. It has all these numbers that Professor Gerhardt was talking about with respect to Obama's nominees. But there's a new concerted effort amongst progressives to push back, to try to make the courts a more important part of the progressive agenda. Do you think that has a potential to work? Does the input from people in the grassroots, does that make a difference if the Concerned Women of America and the National Rifle Association are beating up folks on Capitol Hill? Does it make a difference if folks like us are trying to chime in as well?
Well, I think it does. I mean, but it may make a difference in ways that are very hard to measure, at least in the short term. And so I think that what happens is that, in many respects, sometimes the Supreme Court nomination is about the last battle. It's like, oh, whatever the last case was that was controversial or divisive. And but what happens is, when you talk about the Supreme Court and take a long review, it turns out to be a lot more issues involved, and sometimes you don't even foresee them. If you go back to the great controversy of the Supreme Court at the time of the New Deal, the great controversy at that time was over the New Deal. Will the Supreme Court uphold the constitutional foundations for progressive laws like minimum wage or National Labor Standards Act or whatever else it may be? So the focus was all there. But in time, the court ended up splitting over whether or not there were rights protected by the Constitution other than the right to contract, and splitting in other areas such as separation of powers, because nobody had really thought about those, and because it's hard to come up with an ideology or judicial philosophy that's going to encompass all the right results on all those different issues. This is what it goes back to my point about, is it really about principle or is it about results? Because if you want principle, it won't always lead to the results you want. It won't. Sometimes it would mean you've got to accept a result because it's dictated by your principle. But if you care about results, then sure, just put a politician up there, and that person will, put his or her finger in the wind, and that'll be all there is to it. And at some point, those of us who teach law hope law matters. Law makes some difference, but it's a sophisticated thing to try and figure out what does it mean to say something's settled or not settled, what is something that's protected by the law or not protected. Those, except for the folks in charge of our state government, those are very tough questions. For them, it's simple and, by the way, grounded in the 1950s. But if you really care and are acting in good faith and care about principle, then you've got to roll up your sleeves and do the hard work of figuring out what does it mean to say something's legal or not legal.
Other questions from here in the back? John.
Professor Gerhardt, can you provide us Justice Scalia's position on the Washington, D.C. Second Amendment case?
Yeah.
And
D.C.
how
Health?
that fits into that sort of the larger principle?
Well, sure. So Justice Scalia obviously wrote the court's opinion in what is now a famous case called D.C. versus Heller, which is it's not the first time the Supreme Court dealt with the scope of the Second Amendment, but it is a pivotal Second Amendment decision. And it's one that was decided 5-4, in which the Supreme Court upheld that, or held, that the Second Amendment protects an individual right to own a handgun for purposes of self-defense. It's almost absolutely protected. He did say, well, it may not be absolute, and he pointed to a number of different laws that might actually be permissible. And what's happened after Heller is the courts have had a tough time figuring out sometimes what exactly is the principle we need to follow to figure out which laws would be permissible and which would not be. Maybe we can't restrict people from owning handguns in the privacy of their own homes. But what does it mean about distributing, let's say, an AK-47 at a gun show? Or what does it mean about making certain size magazines available, gun clips available, and so on? Those are more nuanced questions, are harder to figure out. Look, they're not. One advantage, I guess, of growing up in Alabama is I know if you go hunting with an AK-47, it's not real effective. Not if your quest is to get food. And so I think so. There are questions that the court that decision doesn't answer. But it is a decision of the Supreme Court of the United States. It's a decision the Supreme Court has followed. And now what the current Supreme Court's got to figure out is what exactly does that right prohibit and what might it allow.
Other questions? Over here, sir.
The conventional wisdom, I think, is that President Obama's appointment was textured to put the Senate on the spot, to make it difficult for them to find a non-political justification for rejecting it. I wonder if you have any speculation, if assuming a Democrat is elected president, whether there'd be a different appointment, a different appointee. I guess
it would be pure speculation. I will have to say that when President Obama chose Merrick Garland from the D.C. Circuit as his nominee, it surprised some people. In fact, I had a colleague of mine say to me on the morning of the nomination, we were sort of walking down the hall, and she saw the list of 3 people and said, oh, it's going to be X. And I said, really? I think it's going to be Garland. He said, oh my God, why would it be Garland? And I said, exactly because of that response. Garland is the oldest, so this goes to your point. So what makes Garland, in a sense, appealing might not be the right word, acceptable to some people, some Republicans? He's the oldest nominee since Lewis Powell in the early 1970s. He has the longest service as a lower court federal judge who's been nominated to the Supreme Court in American history. Mm-hmm. So when Pat Toomey says, oh, he opposed Elena Kagan because she lacked judicial experience, then one would think, oh, well, he must support Garland, except he wrote an op-ed saying he's not supporting Garland. Okay, good luck reconciling that. But I think the other reason why Garland might have been an astute choice, and I think people have made a living, or perhaps had a hard time making a living, because they've underestimated this president. I think that what happens with Garland is, you can't forget he's a friend of both Bill and Hillary Clinton. he was appointed to the court, his current job, by Bill Clinton. And that's because he was a friend of Hillary Clinton's. So if you're Barack Obama and you say, well, gee, if I got to nominate somebody, but I can't be entirely positive they won't go through, maybe one argument to think about is appointing somebody who will be hard for Hillary not to go with. I'm not saying she would, she can do math better than me. And she can say, look, a 62-year-old nominee is not as good as a 45-year-old one, from her perspective. That's a reasonable outlook. That is an outlook many presidents have taken. But she could also say, oh, I know Merrick Garland. I think he's well qualified, and I'm going to renominate him. So I could see either of those things happen.
One of the best things about NC Policy Watch lunches is we sometimes have political leaders join us. So we have Senator Terry Van Dyne is with us today. You have a question?
Well, at the beginning of your talk, I thought I heard you say that you did not think that this obstructionism would succeed.
Right.
What do you mean by that?
Yeah, it's a fair question. So I think, so the obstructionism presumably is done for a reason. It's done because of arguably some benefit. So I'm hypothesizing that I don't think it's going to get them the political support that they think it will. I think it's going to help lose the Senate for the Republicans. And I think the second thing that's going to happen, at least again thinking at a personal level, is I don't think it's going to keep a Democratic president from filling the position. So in those senses, it fails. Now, whether or not it fails as early as, let's say, the day after the election, I don't know. Because as I also said, Senator McConnell said, no, not on my watch. It's not going to happen. But he could have an insurrection after his party gets completely obliterated in the fall. There could be a lot of people saying, thanks, Mitch, and not wanting to go. They're already going down with the ship, but they may want to one last gas before they go down. That analogy was lost as soon as I started. And so, but that's what I mean. So whatever good thing people think would be achieved is, I'm guessing, may not.
Thank you.
A couple more. Right here in front, sir.
Do nominations expire with the president that made them?
They expire with the end of the legislative session. So it will expire. Now, this has also raised some questions because it turns out the legislative session ends before the next presidential inauguration. So you're actually going to have, so the nomination will expire in a sense in early January. At the same moment that the Senate leadership changes. So technically, it's not going to, it'll be hard for the new leadership to say, oh, let's go with Garland at that point, because technically it's lapsed. And I'd have, again, just pure speculation, I would have a hard time imagining a President Obama and let's say President-elect Clinton work out a deal where if it expires, President Obama remakes it. I have a hard time envisioning that would happen. I think, at that point he says, look, this is your call to make, which means nothing happens till she comes along.
I feel like I read that President Eisenhower actually, didn't he appoint Brennan in some sort of a
recess appointment,
appointment, and then it was later resubmitted or something?
Yeah, so I did not go down that road. So
sorry,
because that's a very messy road.
Sounds very far-fetched.
So there used to be something called recess appointments. And the idea behind recess appointments is that if there were a vacancy that arose because of or during a recess, then the president could fill that position. Now, George Washington did that on the Supreme Court, and a number of other presidents have done that when it comes to judges. The problem is, as a practical matter, we no longer have any recesses.
I see.
And that's a result of a fairly recent Supreme Court decision which upholds a Senate practice of holding what are called pro forma sessions, which are short little sessions designed to prevent the occurrence of a recess, during which the president could appoint somebody to some kind of position. So as a practical matter, President Obama will never have a long enough break to do that.
Over here.
Quick question and a brief comment. The quick question is, wasn't the Heller case join the Bush v. Gore as an example of Scalia departing from this position of going strictly by the language of the Constitution? I mean, I thought a militia had something to do with,
Well, so the short answer is, I'm going to just kind of give him sort of just kind of give him the assumption that his opinion tries at some length to explain how this right we just talked about is grounded in the original meaning. So he looks at the language and says that opening precatory language in the Second Amendment doesn't condition its scope, and then looks at what the common law protected as a fundamental right, and says that would have been incorporated within the Second Amendment at the time of its adoption. The common law at the time of the ratification.
I was no English teacher. I think that was a conditional language introducing the Second Amendment.
And Justice Stevens, who was a formidable justice in his own right, dissents in that case, and obviously takes him to task on the textual language. But one thing to keep in mind about Justice Scalia as somebody who was an originalist is, for him, the original meaning was synonymous with the text. One and the same thing. So that's why you could look at the Equal Protection Clause and say, it's really all about one thing, he would say. It's about eliminating laws based on race. Even though if you read the actual language, it says no state shall deny any person equal protection laws. It doesn't say anything about race. But he would have said, doesn't matter, original meaning, in my book, Justice Scalia's book, is on the same level, and again, synonymous, identical.
How did you know that?
Well, the idea behind original meaning is to kind of do your historical work, do your historiography, and get into what he would say would be the general public understanding of what these words meant at the time they were ratified.
We're about at the end. I've got one last question here from David Bland.
I must bring you to today. Could you speak just for a moment about the impact of the governor filing countersuits to the Department of Justice and where that leaves us as a state?
The short answer is holding the tab. So I guess I was quoted in the NNO today to some extent about this. Kevin's rolling. Let me see how I can say this in a way that won't get me fired, at least immediately.
The professor does not speak for the University of North Carolina.
Yeah, thank you. I don't speak for the University of North Carolina Law School, the University of North Carolina Chapel Hill, anything that's sooner than anything else, but I still like my job. I think what's going on with HB2, I think with HB2, and we can see this even up until the filing of the lawsuit, all these things have something else in common. I think these are all just simply political choices and political positions which are searching for a legal rationale. These are not legal arguments. And so I think many first-year students in law school would tell you, gee, I think HB2 and the whole law in general has a problem, even apart from state law, has a problem under federal law. Under Title IX, under Title VII, we'll keep going down the list. And wishing it were otherwise doesn't make it so. And that's what I think about the lawsuit.
Well, on that note,